today's Global Connections program. I'm Bill Miller. Today we're going to focus upon the judicial system in general and the Supreme Court in particular. My guest today is an expert on this topic. Judge Thomas Moukawsher is a Connecticut complex litigation judge and former lawyer, legislator, and lobbyist. He is the author of The Common Flaw, Needless Complexity in the Courts and 50 Ways to Reduce It. He recently authored a Newsweek article on the Supreme Court's immunity ruling and what it means for the Nuremberg principles. Judge Moukawsher, welcome to today's Global Connections program.
Thank you, Bill. Glad to be here.
Your timing is impeccable. I'm telling you, your articles are right on topic here. I might mention before we get into it that if any of our viewers would like, they can check your website at www.thomasmoukawsher.com. We'll put it up on the screen in the lower thirds. But again, we're very fortunate to live in the United States. We have a constitution, a U.S. Constitution that set up the executive, legislative, and judiciary branches of government. They were really identified to have checks and balances so that one wouldn't get too powerful or do something that's too illegal or whatever the case might be. But it seems like our system has really gotten out of kilter here, especially with the judicial system. Let's just open it up and talk about the Supreme Court of the U.S., SCOTUS, that is so often called. And how do you perceive SCOTUS today as far as how it was supposed to operate by the founders of the Constitution, and when we talk about the rule of law?
Well, I'm happy to comment on it because I should point out I am now a retired judge and can safely talk about the Supreme Court or favor. But I think we're in a revolutionary time with respect to what this court is doing and has done. It's been an incredible year this year, and I think you sort of start at the top with the ethical considerations that have been raised with respect to Justice Thomas and Justice Alito, and that they really shake the foundations of American trust with respect to the Supreme Court. And I've certainly written on and very strongly believe that one of the first things we need to do is to have an enforceable ethics code. I certainly think it was good that the court started by adopting an ethics code, but an ethics code that's toothless is as good as no ethics code at all. And I think that's been highlight of this year, and the need to actually have some enforcement mechanism is imperative. And I think they can do it without having a perpetual witch hunt of members of the Supreme Court by a commission that's designed to undercut them. I think you can do that by having a balanced membership of that commission. I think also that it can be limited in terms of what kinds of complaints can be brought. But certainly the court itself ultimately needs some way to disqualify justices who really have conflicts of interest in cases, other than asking them to think about disqualifying themselves. So if you start at the top of a very long list of Supreme Court concerns, that's pretty much at the top.
It certainly is. And you mentioned Judge Clarence Thomas, and not to pick on him, but he seems to have the longest pedigree as far as violating the ethics. He has been involved in receiving, it's been reported, I think documented, that he's gotten over $2 million in free trips, cushy loans, that type of thing, just a variety of perks given to him. Not to mention that his wife was actively involved in the illegal attempt to illegally overthrow the U.S. government and a free election back in 2020. And so he seems to be leading the group right now. What can be done when someone is violating, certainly not the law, which I think he is the law, but ethics so egregiously? What can be done against or to rectify it?
Well, I don't think we're at this point yet, but I know that some members of the House of Representatives have submitted articles of impeachment against Justice Thomas. And I don't think that's the way to go, because I do think that the court would be better served in policing itself. I'm sure the Chief Justice, who I know loves the institution, has doubtless talked to Justice Thomas and Justice Alito and told them about a very important principle, and that is the idea that justices should not only avoid improprieties, but they should avoid the appearance of improprieties. And even if you don't dig down and investigate everything about Justice Thomas's wife's involvement in some of the cases that Justice Thomas has sat on, the fact that it just would appear to a reasonable person to be improper should be enough that Justice Thomas should have recused himself in those cases. And I don't think that he has taken the obligations of the new code, that the unenforceable code they adopted, seriously. So some mechanism has to be created within the court. I think it should be a commission created by the court itself that could force a justice to disqualify himself, as opposed to leaving it entirely to himself.
Mhm. That would be a logical way to go at it, no doubt about it. And hopefully they'll move in that direction. It's so important that I think all three branches of government have to maintain certain ethical levels for the public to have confidence in them. Of course, we've seen, well, really for the last several years, Donald Trump has been undermining the judicial system. Well, he's undermining all of our systems, talking about the false illegality of elections, that type of thing. How important is it for the public to have faith and confidence in these systems in a democratic society?
Well, I remember when the first day I took the bench as a brand new judge, I walked out into the room and there were 100 criminal defendants in the room. And there were two marshals. Neither of them were particularly physically fit and likely to be able to fight off 100 people to protect me. And I got up there and I realized that nothing stands between me and this 100 people except their faith in the rule of law, their willingness to cooperate with the process and to speak when they're given the chance, and to be quiet when they're asked to be quiet. And so you have a room full of people, and it only works because they believe in the system. If we undermine that belief by making them think that the courts aren't honest in the United States, or can be bought or postponed or delayed or frustrated, as we've seen lately, then we're bound to lose the thing that holds us together, and that's faith in our institutions. I'm sure you know that the Russian Federation has a magnificent constitution. It's more beautiful than ours in many ways. It guarantees more rights than I do, but they don't mean a thing because there's no public support and no faith behind the words. We're in a faith-based universe here. And if we lose faith in our courts and in justice in general, we're going to lose justice.
That's very true. And it's important for the American public to have this, but you mentioned domestically. How important is it for people from overseas to view our system and to look upon us as, really, we were for a long time, I think, perceived until recently as a shining democracy, and a lot of countries want to emulate our democracy here, and now they see what's going on here. But how important is it for people overseas to believe this too?
Oh, absolutely the same thing. In other words, we had the moral standing to lead the world. People wanted to be like us. People trusted us because they believed that the United States stood for justice all over the globe. And while we've tripped up a few times and made our mistakes, you wouldn't want to compare us with the alternatives of the authoritarian countries that exist today, or those that existed in the 1930s and 40s, and which caused the globe to turn to us for leadership. And I think they're worried about it now. I certainly think they're worried about it if former President Trump regains office. And I think they should worry about it, and I wrote about this with respect to the Nuremberg principles. And, I grew up in an era in which the United States was a shining city on a hill, because it insisted that the Nazi criminals be brought to the bar of justice. And the alternatives viewed by both the Soviets and the British were that we would just shoot around 50,000 top Germans after the war and have it over with. And instead, the United States insisted that we establish the rule of law after the war and that people be put on trial. And if you look at the results of the trial, the results were thoughtful and indeed varied. Some people were acquitted, some people received prison sentences, and others were sentenced to death. But it was a deliberative process and yielded results that I think the world for a long time had confidence in. But now, if you see what the United States has done in walking out of international courts of justice, and then our own court giving the president absolute immunity with respect to what he does in foreign policy and as commander-in-chief of the military, well, there's not going to be any American because the president can't be prosecuted in the United States, and the United States won't participate in the International Criminal Court. So you have this situation in which I think we lose ground in terms of that moral authority that's led the world for so long, when we're basically telling people we aren't accountable to anybody unless perhaps we're defeated as the Germans were in a war, which, ended up, I wrote in the article I did recently saying that, maybe Hermann Goering was right. It was Victor's justice. He said, we would have done the same thing to you people, he said. And I hope we can still prove him wrong.
Let's hope we can. I'm glad you brought up the Nuremberg principles and the other items, since you mentioned immunity, and we'll be back in just a minute to talk about those. But for the moment, you're watching Global Connections Television, which is a privately funded, independently produced program. The opinions expressed on Global Connections are solely those of the moderator and his guests. We'd invite our viewers to go to our website at www.globalconnectionstelevision.com to view previous programs. Also, if you're involved with a PBS or community access television station, or perhaps an educational institution that has an intra-campus television hookup, or you have a podcast, or you just have a computer, you like our shows and you'd like to share them, please feel free to do so. Global Connections Television is provided at no cost as a public service to help us better understand international issues and how they impact our lives. Today, we're taking a look at the judicial system in general and the Supreme Court in particular in the United States. And my guest is an expert on this topic. Judge Thomas Moukawsher is a retired Connecticut complex litigation judge and former lawyer, legislator, and lobbyist. He is the author of The Common Flaw, Needless Complexity in the Courts, and 50 Ways to Reduce It. Judge, your book title is perfect. It's right on target, as we've seen this can of worms over the past couple of years, really. But before we leave the international, why is it, well, as you mentioned, we've been sort of a shining city on the hill for decades, especially even when the UN was founded back in 1945. So much of the UN, the charter in 1948, when they drafted the Universal Declaration of Human Rights, so many of the documents were not copied verbatim, but they were used to some degree to develop those documents, and they were extremely important and still are. But why is it important for us to be involved in the International Court of Justice, which is one of the 6 organs of the UN, and the International Criminal Court, which we are not a member of, even though it was set up by the UN, but it's separate from the UN to some degree?
Well, I think it's important to participate in the global community in attempting to work out difficulties between nations or to deal with criminal acts that are international in a cooperative way. If the only resource you end up having to turn to is perpetually violence, then we have a world that's threatens its own existence, as we know, given where we stand with weapons and power that people hold in this day and age. Trying to come up with methods of resolving peacefully disputes among nations is critical. And if you say that, okay, we'll participate in an institution when it's prosecuting someone we don't like, but we won't participate if anyone makes an accusation against us, undermines our moral authority, but also undermines any mechanism that might keep the peace in the world. Because if you can't bring a an international criminal to justice any other way, then that person gets brought to justice through war. And after World War II, I think we realized that another world war might be the end of us. So that kind of participation is not just to keep a good reputation for the United States, but it's to keep the world safe from its own destruction.
Exactly. And if we did have World War III, it would be absolutely devastating. There's no doubt about it. That's why so many people are focusing on how important Ukraine is and how important it is to make sure that Russia does not get its hands on Ukraine, because they have bigger ambitions to move into Poland and some of the Baltic countries and what have you. And so it's absolutely critical. Well, if we could come back to America for a moment, and you were talking about some of the rulings of the Supreme Court, recent rulings. You talk about the immunity. How devastating is that? That seemed like an easy one to rule on, and it took forever. Of course, they were foot dragging. Obviously, they were slowing the train down to help Donald Trump. In my opinion, anyway. But how important is that ruling? And we'll mention a few others as we go along.
Well, it's always easy to slow down a legal proceeding, and that's one of the
Right.
everything that's going on right now with the former president should have been resolved years ago, shortly after he left office. And the fact that he's a master, really, of slowing things down, he knows how to do it. He's been engaged in litigation his entire adult life. And so he's tied the system up in knots very effectively. It's the system's fault that it's allowed itself to be tied up into knots. But as for the immunity ruling itself, I think that the Chief Justice was sincere in his concern that former presidents not simply be continually harassed with litigation, criminal in particular, against them for the policies that they adopted while in office. There's a genuine concern there because, of course, there's been some suggestion that Donald Trump, if he won back the presidency, would immediately attempt to prosecute President Biden. And I don't think we want a world in which frivolous claims are brought against former presidents as a matter of course. So I certainly agree with the Chief Justice and believe he was sincere in trying to curb that, to try and prevent that becoming an overwhelming problem. The trouble is with the absolute immunity end of the decision, in which the Chief Justice and the majority of the court held that a president simply can't be held to account at all for anything when the president is carrying out his so-called core functions. As I mentioned earlier, two of them that are highlighted in my mind as a consequence of the decision are foreign affairs and commander-in-chief and the commander-in-chief function. But the Supreme Court listed several others: the pardon power, supervision over cabinet officials and things like that, in which the president could effectively run a criminal enterprise and would be completely immune from being held to account for it. It's this absolute immunity with no exceptions part of it that deeply troubles me. And I think that future courts are going to have to look at that and start to deal with the definitions of what are core functions. For instance, would it ever be part of the core function of a president engaged in foreign policy or war to commit a genocide against an entire people, to attempt, for instance, to eradicate a race from the earth? A court could, I would hope, still find that that's no part of the president's powers in foreign policy. But this court suggested that once you've decided it's foreign policy, end of inquiry. You can't look at what the president was trying to carry out or anything else. And that is deeply troubling.
Mm-hmm. And the immunity issue really has not been that big of a problem for previous presidents. A lot of legal scholars were saying if there ever precedent or ever an opportunity to bring charges against a president after he's out of office, is George W. Bush, who launched an illegal invasion of Iraq. And if you can't bring a charge against him, who can you bring it against? But they didn't. They did not do that. And it's really never been a problem up to this point. But that's not how the Supreme Court saw it. Well, what would you suggest? There are a lot of the ideas floating around right now. Some folks want to, if the Supreme Court doesn't develop a meaningful code of ethics with teeth, then Congress, the Senate should do it, or somebody, Congress, the House won't do it at this point. We know that, but they should do it. They were talking about having a situation where there's term limits for the Supreme Court justices, or each president would get 2 justices per term or something like that. What suggestions would you have?
Well, I think them adopting their own enforceable ethics code might head some of this off. I think the most intriguing one of the ones you mentioned potentially is a term limit. I don't know, based on number of years in office or based upon age. I'm not sure which, but to explore that would make some sense. The idea of reviving the old Roosevelt court packing plan does not appeal to me. I think that really would weaken the judicial branch as a co-equal branch of government in lots of ways, and just invite ever more additions to it based upon whatever president didn't like the makeup of the court. And you could end up with a Supreme Court with 23 members or something.
Or 130 or something.
I think
that's an extreme. I don't know.
To keep the judicial branch strong as a check and balance on the other 2 branches, I don't think we should undercut it. But there is some argument to be made that at least some form of term limit, I wouldn't say 10 years or 20 years, I'm thinking more like 30 or 40 might be something that would make some sense. But of course, then they'll start appointing justices who are in their 20s.
Exactly.
That's
law school.
Yeah, they might as well just day you graduate from law school, you're on this. And that kind of thing is worrisome too. They're actually appointing justices, and I think the presidents have come to appoint judges at ever younger ages because they want their impact on the judiciary to last longer. And I think that's extremely foolish, because an inexperienced judge just isn't capable of delivering justice in the way experienced judges are.
Exactly. We see it every day, especially with Judge Eileen Cannon in Florida with the stolen top secret documents. We see that. Well, Judge Moukawsher, this is so important, and I wish we had more time. We'll have to get you back. This is not a story that's going to end next week, that's for sure. But I want to thank you so very much for a very interesting and a very informative program.
Thank you very much for having me, Bill. I always enjoy it.
Okay, my pleasure. I'm Bill Miller. Thank you for joining us today on Global Connections Television.